how they are spending money of CA members. One is I showed what happened, Mr. Bhupati cross examination. That was here. One thing you should remember, friends. The institute lawyer was always depending on my apology letter. In so many years the cases was coming, no? He was telling, what is this case? This fellow has already apologized. And where is the case made out? So, I used to feel that is a point. My apology letter is published. And even earlier I used to appoint some other advocates who helped me a lot, but they were also thinking, no, why we should do. Then with the knowledge I gained over a period, I realized what is the defense of the opponent. First and foremost step, you should be prepared. This is the first rule of winning. You have a good case, I have a good case, but that does not mean one side story it will become. Always you should see what is the opponent's defense. You have to concentrate on that only first. You should protect your defense, and the opponent's defense you should demolish. You see, I knew what is his defense. There are two defenses he is taking. Let us see, I will tell you. So, first this came for this thing. A day before, judge told that that senior sent is a junior, but that lady also is a senior lawyer. Nice, they are very brilliant judges, lawyers, both of them. And she started telling that it is already apology letter is given. So, where is the question of going on talking about it? First she said, no, my senior is not there, and therefore you give some other date. Then I told the judge, Lordship, the senior counsel, that madam is herself is brilliant and she can argue. I am too small man, my case is too short. Why such big seniors are required? And my case is simple, my lords. I made allegation, I filed a complaint. These are my ground evidence. They have rejected it. So judge said, see, I will do one thing. I will refer it back for reconsideration. And then that madam took a stand. This man wants an independent inquiry committee. How is it possible as per law? So honorable judge said, this 226 I am powerful. I can order for a independent inquiry, but not now. At this juncture I am not going to do that. But I can do it. Then she immediately said, but she said, you give one chance. Please, only one chance, my senior will come and argue. So on that day I knew I won the case. See, case is clear. But then I realized at that night how the other senior will take up the case, will take up the matter, and how to argue. What is that his defense can be? His defense is one, is about my apology letter published in the CAN journal. Do I have an answer for it? Second, he may come out with a similar case. He can say, what is this man is aggrieved about? He has filed a case against N.S. Srinivasan, saying that he is talking about Bhupati. Why should CA should be made responsible? He will be his second defense. He kept it to the last. I knew only this. So on that day, that case came. So he beautifully will argue. Mr. Krishna Srinivasan, very good voice, runs through. He just started that. Lordship and all, half an hour. His defense is, if only this man is aggrieved, he should go to civil defamation. He only should go to others criminal defamation against that fellow. Why should institute platform be used? Judge told me, yes, I think there is a point in what he says. So I will dismiss this petition, he said. So much distance we have crossed. The last minute, it was declared as good as going to be dismissed. Understand? And I knew that this will be his defense. I am a party in person. Remember, friends, if I lose this case, the institute will become vindicated stand, because other two presidents are also suffering the same matter, same subject. If I win this case, they will all come into the disciplinary mechanism. Consequences will not be easy. So, ready. I took this out won. I won the case only because I told my lords, I have made 3 charges in the form. It is a complaint I made as per the procedure, form 1. In that I made 3 charges. For that 3 charges, this is my evidence. First charge, this man made allegation against me, and as a consequence of that I was removed from the classes. My goodwill is lost, and this gentleman in the cross-examination inquiry committee, what did he say? Committee report is this. He himself agreed. Committee has also said that he has not is unnecessarily made the allegations. So this is established. Second charge, his grievance is disciplinary committee is that I spoke bad of Bhupati. That is his sum and substance. 1. Bhupati should have filed case against him, which he has filed. It is not same grievance, he filed the case. Now what happened in the cross examination? It is evidence. He has admitted to all his, he said, Venkatasivakumar said, I have travelled foreign country. Venkatasivakumar said, I am running coaching center with my wife's name. Venkatasivakumar said, I have used my directors in all CA platform to promote them. Venkatasivakumar said, I have taken money from Pricewaterhouse while I was fighting against them outside. The flying points, I have utilized it, and I was running coaching center. I have made lies, everything is recorded. So how can my apology letter be the basis? My apology letter is estoppel. It is cheating they have done, for which they have to pay me money. How can they use it and remove me for this long time? Then I told the judge, if they are not, the way in which they dismissed is not on maintainability. They have gone through that provisions, everything. And then they found me this thing. Can they, now the question arises, can this member be eligible to be in a profession like this? Causing me immense damage. And ignoring the evidence. What is that they wrote for this? There is no evidence, there is no evidence, there is no evidence. And I gave you evidence, why you have not taken it? That's my case, my lords. He was convinced, judge. Yes. Then he was telling so many things. He said, okay, tomorrow I will pronounce the judgment, day after tomorrow. And any clarifications I need, I may ask you, Mr. Venkatasivakumar. Otherwise, orders reserved, he said. Then I knew the judge has come to the conclusion, and so now I prepared a written submissions. In the written submissions, typed set reference I gave, I will show you. Very easy for the judge to pass the order. Understand? Here my question is, my evidence is not considered. I was not given hearing. He has taken some papers, passed the orders. And you see the way in which judge wrote, that I didn't know, but judge came out with that principle. He said that, we will see that, I will read out the judgment, beautiful judgment. He said, when in any disciplinary proceedings, the adjudicating authority first take a charge. Evidence. Evidence may be documentary evidence or other evidences or cross-examinations. All will have to be fair hearing. After taking that into account, I have taken these things into account. This is the charge, and I also taken the other person's view into consideration. And then why I am taking up or not taking up, you should write. The connecting link is not there. That is called fair hearing. Beautifully he has analyzed. I will read out. It is a landmark judgment on the principles of natural justice. No Supreme Court till now connected like that. I have read, I am a specialist in teaching principles of natural justice to masters of law students. That I will take the order. You see after so long I have come, my case would have been gone, because the way in which the outside other lawyer convinced. I knew his defense will be that only. How to defend that? What are the charges you have asked to make? I made charges. You have processed the charges. When I gave evidence, you said there is no evidence, and so when you say an evidence is not there, then why did you acquit him? He says there is no evidence. Generally, when you show the evidence, that is not correct, and the order is passed. Let us take to the judgment in detail.